Delta plc own a small office. Delta asks Frank, an electrician, to undertake various works at the company premises and tells Frank that his work will take about 1 week. While Frank is working in Delta's offices, he carelessly rewires a switch and Gloria, an employee of Delta, is injured when she uses the switch. Henry, who is visiting Delta in an attempt to sell some office equipment, is also injured when he trips over a length of electrical cable that Frank has left in a corridor. Advice Gloria and Henry. Now, what you have to answer: firstly, the liability of Frank; secondly, the liability of Delta or Frank; and thirdly, any non-delegable duties of Delta for the torts of Frank, independent contractor. We must decide whether Gloria and Henry could sue Frank for the tortious conduct under traditional negligence and, if so, whether Delta plc is vicariously liable for Frank's actions. Both must first show that Frank owes them a duty of care. In those situations in which a duty of care has previously been found to exist, there is no need to apply the incremental test preferred by the House of Lords in Caparo Industries Pick v. Dickman, 1990. In fact, a duty of care has been found to exist in a similar situation in Green v. Fiberglass Limited, 1958. However, even without knowledge of this case, he could deduce the existence of a duty of care. It is reasonably foreseeable that, by carelessly rewiring the switch, a person who uses it may suffer injury, with both physical and temporal proximity being satisfied along with the fair, just and reasonable criterion, as there are no policy reasons to deny a duty. Next, it needs to be shown that Frank was in breach of this duty, that a reasonable person, or rather a reasonably competent electrician, in Frank's position, would not have acted in this way. Blythe v. Birmingham Waterworks, 1856, Bolam v. Friern Hospital Management Committee, 1957. It seems clear that a reasonable electrician would not rewire a switch carelessly, or leave a loose electrical cable exposed in a corridor. The likelihood of injury, Botten v. Stone, 1951. The seriousness of electrical shock and tripping over a cable, Paris v. Tkma 0951, coupled with the simple practicalities in avoiding such risks and taking care, removing the cable from the corridor, Latimer v. Eck, 1953, all point to a clear breach. Both Gloria and Henry will also have to show that this breach caused her injuries, and the Butford test in Cork v. Kirby MacLean, 1952, proves the required causal connection. Finally, both will have to prove that the damage that was suffered to both was not too remote, that is, that it was reasonably foreseeable. The Wagon Mound, No. 1, 1961. This should give rise to no problem, as all that Gloria and Henry will have to show is that some personal injury was foreseeable. The extent need not be foreseeable, or the exact manner in which the injury was caused. Smith v. Leechbrain, 1962. Hughes v. Lord Advocate, 1963. In our case, physical injury was at least foreseeable, and therefore both could overcome. Both have to show that breach has caused the injury. The Aberdford test in proving cause of injury and damage was foreseeable and not too remote. Now what has to decide that whether Delta is responsible for act of Frank? To check this, the original test was control test as discussed in Ewens vs. Noakes, 1880. Denning proposed the A business integration test. Does the person do his work as an integral part of the business, when he will be an employee, or is he merely an accessory to it, when he will be an independent contractor? In Ready Mixed Concrete v. Minister of Pensions, 1968, McKenna J. laid down several conditions for a contract of employment, one of which was that the worker agrees to be directed as to the mode of carrying out the work. However, this condition seems to be lacking in Frank's case, leaving him as an independent contractor. Similarly, the modern approach taken in Market Investigations v. Minister of Social Security, 1969, was to take a fuller and multiple assessment of the facts of the case. Looking at the facts of Frank and Delta plc, it would seem that Delta plc has the right to tell Frank what work is to be done, but not how to do it, so that Frank is an independent contractor. However, if this is overcome, it seems reasonably clear that Frank was acting within the course of his employment, provided that the relevant act, that is, the rewiring of the switch, was an authorized act. The fact that Frank has carried it out in a wrongful and unauthorized manner will not take the act outside the course of his employment. Century Insurance v. Northern Ireland Road Transport Board, 90. As regards Gloria, Delta plc is under a non-delegable duty to take reasonable care for the safety of its employees. Wilsons and Clyde Cole v. English, 1938. By the phrase non-delegable, the employer cannot delegate responsibility for performance. Thus, although the standard rule is that an employer is not liable for the actions of an independent contractor, Morgan v. Girls Friendly Society, 1936, D. and F. Estates v. Church Commissioner, 1989, Delta plc will be liable to Gloria for failing to take reasonable care for her safety. Concerning Henry, as he is not an employee of Delta plc, he may only rely on suing Frank in negligence as established earlier. However, there are some situations in which an employer is liable for the torts of an independent contractor. See the fact-specific criteria in Woodland v. Essex County Council, 2013. For example, one of the situations that may be relevant as regards common law non-delegable duties is where the independent contractor is employed to carry out work that is extra-hazardous. Honeywell and Stein Limited v. Larkin Brothers, 1934, Alcock v. Wraith, 1991. In Alcock, the Court of Appeal held that a crucial question was, did the work involve some special risk or was it from its very nature likely to cause damage? The work here was not extra-hazardous and so Delta plc will not be liable. Salisbury v. Woodland, 1969. If it were decided that Frank's work was extra-hazardous, Delta plc might be able to claim that Frank's negligence was merely collateral to the performance of his work and that it was not liable. Padbury v. Holiday and Greenwood,